Hello, everyone. If you could kindly take your seats, we're going to get started. I have a few announcements I'd like to make to clarify materials. So that you know, there were 3 new handouts outside at the tables. If you didn't get them, you can still get them after the program. One was an addition to tab 18, so you have materials at tab 18. There's another handout from Heather Zordell provided to us today, so you'll want to pick that up. There was a 1-page from Bourque for tab 3, and there was tab 2, which was Brian Ludmer's materials in place of Mr. Anisman. So it does say Phil Anisman, but these materials were prepared by Brian Ludmer. So you might want to just make a note of that for tab 2. Finally, regarding the presentation you heard just before the break, Mr. Voore, he will be providing something to us by email after the program, and we will forward it to everybody in the program. And that was tab 8. And finally, if you're missing any other tab, it is in your materials on the side pocket. There's lots of the tabs are in the side pocket, so please look there for tab 13 and some of the other tabs. I hope that clarifies all the questions, and for those of you who are waiting for binders, they are being printed. Our apologies, they will be available for you after the program. Thank you.
Okay, I'll take this opportunity, even though I think we do have a minute left, to introduce our next speaker, and we'll see if we can save that minute up to use somewhere in the program. Our next speaker, Mihkel Bennett, is one of my partners at Ogilvy Renault. He practices in the area of corporate securities law. Mihkel is the technical expert that many of us go to when we have the tough questions. In particular, he's done a ton of private placements on which he's going to speak to us today. This has certainly been an area of rapid and never-ceasing change. Just in Ontario alone, the continual machinations of the various private placement exemptions, those of us who don't do it as often just throw up our hands and say, I'm not going to follow it anymore, and I'll just go down the hall and ask Mihkel. So you get the benefit of what I get the benefit every day, and Mihkel?
Thank you, Brian. I had emailed my paper to the Law Society, and when the paper was printed for your materials, the formatting went askew. So if anyone wants a copy of the paper in a more easily readable format, contact me and I'll be glad to send one to you. In recent years, there have been a number of changes to the regulatory regime applicable to exempt offerings in Canada. The paper in your materials briefly reviews those changes. My focus this morning will be on changes in the last year. As a result of recent regulatory initiatives, there are now basically 3 private placement regimes in Canada. The first is Ontario's regime, set out in OSC Rule 45-501 on exempt distributions. The second is Quebec's regime, set out in the Quebec Securities Act. And the third is the regime of the other provinces and territories, set out in Multilateral Instrument 45-103, entitled Capital Raising Exemptions. While Canada still lacks a single uniform set of private placement rules, it is an improvement that securities practitioners now only have to deal with 3 sets of rules rather than 13, even though one regime still permits some local variations. Of course, when proposing to issue securities to an investor on a private placement basis, an issuer should make sure that a prospectus exemption is available for use both in the province in which the issuer is located and the province in which the investor resides. MI 45-103 was originally adopted in British Columbia and Alberta in 2002. A reformulation of MI 45-103 was adopted in 2003 by all provinces and territories except Ontario and Quebec. The key private placement exemptions in the instrument include the accredited investor exemption, the offering memorandum exemption, the family, friends, and business associates exemption, and the private issuer exemption. It should be noted that Multilateral Instrument 45-103 does not provide for total uniformity. Some jurisdictions have opted out of or varied certain provisions of the instrument. For example, the offering memorandum exemption does not apply in New Brunswick and the Yukon, In British Columbia and Nova Scotia, the exemption can be used to raise any amount of money from an investor, while in the other jurisdictions, the private placement amount must not exceed $10,000 unless the purchaser is an eligible investor, which is a defined term. In Ontario, on January 12th of this year, another reformulation of OSC Rule 45-501 on exempt distributions came into force. The changes in this reformulation were primarily of a technical nature. The accredited investor exemption in the Ontario rule was slightly expanded since some additional entities were added to the definition of accredited investor. The closely held issuer exemption in the Ontario rule was amended by deleting the language which restricted the exemption in circumstances where a promoter is participating. The reformulated Ontario rule also added an exemption to allow for a trade by an issuer in securities of its own issue as consideration for the purchase of business assets from a person or company if the fair value of the business assets purchased is not less than $10,000. In 2003, Ontario also stopped charging private placement fees based on a percentage of aggregate gross proceeds realized in the province from the private placement. As a result of rule changes in March 2003, there was no longer any fee for filing a report on Form 45-501F1, although the form will be subject to late fees if it is not filed within the prescribed time. However, the OSC subsequently amended the rules to require, effective December 1st, 2003, a $500 fee for the filing of a Form 45-501F1 for a distribution of securities of an issuer that is not subject to a participation fee under the new OSC fee rule. I should also note that in August 2003, Multilateral Instrument 45-105 came into force in all provinces and territories except Quebec. It provides for harmonized prospectus and registration exemptions for trades by an issuer in securities to employees, senior officers, directors, and consultants of the issuer or one of its affiliates. This year, 2004, we can look forward to some additional changes. Revised proposed amendments to the private placement rules in the Toronto Stock Exchange Company Manual were republished for comment in the January 2nd, 2004 issue of the OSC Bulletin. The anticipated effective date of the new rules is April 1st, 2004. A reformulation of Multilateral Instrument 45-102 will be effective on March 30th of this year. The reformulation will simplify the resale rules and in certain circumstances permit privately placed securities to be resold sooner. The reformulation provides for a standard 4-month hold period on privately placed securities of a reporting issuer. The new rule also accommodates electronic alternatives to legended paper certificates. As was the case with the previous formulation, Quebec is not a party to this rule, but has its own resale ruling that gives similar but not identical relief. Finally, we should monitor the ongoing efforts of the Uniform Securities Law Project of the Canadian Securities Administrators. In January 2003, the CSA published a concept proposal on the USL. The concept proposal made recommendations with respect to prospectus exemptions. The USL would harmonize and consolidate most prospectus exemptions in a uniform securities rule. However, local jurisdictions would still be able to have prospectus exemptions that would only apply in the local jurisdiction. In conclusion, securities practitioners have had to digest a number of changes to the regulatory regime applicable to exempt offerings in recent years. More changes will occur in 2004. However, to the extent that these changes create a more harmonized regulatory environment, they will improve the efficiency of the exempt market. It is hoped that the provinces and the territories will continue to harmonize their private placement rules. Thank you.
Thank you very much, Michael. It certainly is a very, very fast-moving area, and Michael's materials will be a great reference source for us going forward. Certain of the speakers actually have prepared PowerPoint presentations just to help, because we're throwing it at you so fast. It just sometimes helps in the delivery. Jenny Chu Steinberg from Goodman & Carr is going to speak to us on specialized prospectus offerings has the first PowerPoint presentation, and that should go up on the screen as she's taking us through it. Jenny has extensive corporate finance experience. Goodman & Carr is a very active practice in that area. She is taking the place of one of her colleagues, Gary Kissick, who wasn't able to be here today, and I'd like to invite Jenny.
Thank you, Brian. Now, how do I start this? Do I hit it on? Oh, there it is.
Yeah, it
It's
should
on.
be all set.
Okay, great. Good morning, everyone. Specialized offerings, for purposes of my 8 minutes this morning, will refer to any offering other than a straight common share offering and other than a mutual fund offering. There's really a vast array of specialized offerings, and here we are looking at some samples of corporate offerings. I will not try to describe each one, but we will get into a few of them. Firstly, the subscription deposit receipts, for those of you who've not worked with those, are used by issuers or selling shareholders who want to obtain committed financing in advance of a future event such as an acquisition or regulatory approval. The issuer files and clears the prospectus, the financing closes, the issuer issues the subscription deposit receipts, and often the funds go into escrow. And if the condition is satisfied because the acquisition gets completed or the regulatory approval is obtained, the issuer delivers the underlying stock, which is often the common shares, and usually there's a dividend component that goes with the common shares. And if the condition is not satisfied, the investors receive a refund, again with interest. And we will look at a sampling of recent deals a bit later. Another example, installment receipts are securities, the purchase price for which is paid over time. The investor is making a firm commitment to buy the underlying security, again often a common share, and there is no possibility of a refund. When all the installments are paid, the investor gets the underlying security. It is often used in secondary offerings, and it's a benefit to investors because they are not having to put up all of the full purchase price in one shot. Things can, however, go sideways, as we saw in a couple of deals like Boliden and Fracmaster, where the trading price of the common shares fell before the final installment was due. I think we'll touch briefly on split share offerings by corporations. That's an offering by an issuer of two or more classes of shares, where one class, often a preferred share, is entitled to a fixed dividend stream, and another class, often called capital shares, which are akin to common shares, is entitled to the capital appreciation. And the dividend and capital appreciation are derived from a portfolio of one or more other issuers that are expected to pay regular dividends and expected to have some capital appreciation. Now we're looking at some examples of trust offerings. We have the basic offering of trust units. Recently, we've also seen offerings by trusts where the investor has a choice of either taking a preferred security with a fixed return and a due date, or just the basic trust units, which are really equity with no guaranteed return. Asset-backed securities, often offered by trusts, are securities backed by financial assets that have been segregated and sold to the issuer. The financial assets that can be securitized are really virtually limitless, in that any asset that has a predictable stream of cash flow can be securitized. Examples would include things like consumer credit card receivables, automobile loans, and equipment leases. And the securities that are issued are rights that represent either an undivided co-ownership interest in the pool of financial assets, or it can be notes that are secured by the pool of financial assets. Now, how does one do a specialized offering? It's really no different than a basic common share offering. If the issuer qualifies for the short form prospectus because it has the necessary reporting history and market cap and current AIF, then any issuer doing a specialized offering should be able to use a short form prospectus. Both the long form, short form, and shelf form requirements do contain additional disclosure requirements if you're doing an asset-backed security. From a lawyer's point of view, a bought deal is one of the most straightforward. In a nutshell, for those of you who have not worked on one, really the bought deal is an offering that's announced and filed in accordance with Part 14 of National Instrument 44-101, and it's the one exception to the rule that no solicitations can occur before the filing of a preliminary prospectus, so long as the prospectus prelim is received within 2 business days of the entering into of the agreement between the issuer and the underwriters and the issuance of the press release. Many specialized offerings can be done for a secondary offering. One recent development for secondary offerings that Brian asked me to mention is that in both the long form and short form prospectus form requirements, okay, there is a disclosure requirement as to what portion of the offering expenses are being paid by the selling shareholder, and if none, to discuss the reason. I think what I'll do is I'll jump and show you some sampling of recent deals done by way of subscription deposit receipts. You'll see that there was a recent one done by a secondary offering by Alliant for the common shares of Stratos Global that it held. And the reason for using SDRs in that case was that Alliant was needing regulatory approval in order to be able to sell its position in Stratos. TD Bank, when acquiring Canada Trust back in 1999, filed a prelim for subscription deposit receipts. After filing it, they discovered that investor sentiment was actually that they were quite willing to buy common shares and stick with it, whether or not the Canada Trust acquisition was completed. So in fact, TD pulled the SDR prospectus and refiled a prelim just offering common shares. I was going to cover some recent developments in the income trust world, and I think I have run out of time, so yeah, okay. They're covered on one of the pages of the handout regarding proposed National Policy 41-201. And I guess that's it. Thank you, Bert.
Thank you, Jenny. Our next speaker, Jeff Singer from Steinberg Elliott, his profile is not included in the materials. I worked with Jeff for many years, and I can assure you he's had an extremely active practice transactionally. That being said, again, that would have been too easy, so we gave Jeff mission impossible, which is to update us on events in corporate governance regulation in 7.5 minutes, and it is virtually impossible, but he's going to give us the best synopsis we can.
Thanks, Brian. So I've been given corporate governance at the crossroads, which I think should more aptly be named corporate governance in the crosshairs, as it seems that it's almost impossible to remember a day over the last few years where corporate governance issues have not arisen, typically in the context of massive corporate governance debacles, going back not even so far, Livent, Briex, YBM, Enron, WorldCom, more recently Hollinger and Pamela that we're reading so much about. So what have we seen in response? We've also seen and continue to see perhaps the greatest volume of regulatory initiatives designed to regulate corporate governance that has ever been, making this truly mission impossible. In fact, I've been sitting over there excising chunks of this to try to stay within the 7.5 minutes. So let me give a high level. In the United States, as we've talked about, and I'm going to talk about again in another moment, we saw the passage of the Broad and Tough Sarbanes-Oxley Act and a number of SEC rules, mandatory rules implementing it, and strict penalties and enforcement, including, as we saw last week, imprisonment. Some would claim, as is often the case, that the Canadian response has not been nearly as swift or as rigorous as the American response, resulting in organized activism and initiatives by some of Canada's larger institutional investors, such as owners and teachers, and professional organizations such as the CICA. My discussion will not be an attempt to resolve this debate, nor am I going to be able to delve into the proposals and provisions of each of the very manyest initiatives that have come out. Rather, I've tried as best I could to summarize these in the nearly 100 pages of written materials that you can find at around tab 11 and follow along with. Rather, my goal this morning is to make you aware of some of the more significant corporate governance initiatives and their import. So let's start in the United States. In July of 2002, as we're all aware, the government, the U.S. federal government passed the Sarbanes-Oxley Act, or SOX. Broadly, SOX addresses real and perceived deficiencies in corporate governance by requiring enhanced company disclosure, expanding insider accountability, including most notably through certification of financial statements by CEOs and CFOs, encroaching on matters that would have previously been left to the discretion and judgment of the board by imposing restrictions in loans and to directors and officers and trading during blackout periods, demanding forfeiture of incentive-based compensation in certain circumstances, such as where a company has to restate their financial statements because of material violations of securities laws, requiring the adoption of codes of ethics, and imposing responsibilities concerning the oversight of auditors, and finally, broadening sanctions for wrongdoing. In the wake of SOX, the SEC passed approximately 20 rules to give effect to it. Now, as Pam Hughes mentioned, SOX and the SEC rules really is a U.S. initiative, but has really far-reaching implications for issuers that are either cross-border issuers that have or are contemplating issuing securities into the United States, in which case you need to be aware of them and their import, as well as the rules of NYSE and NASDAQ, which have been recently adopted that deal with corporate governance. I would pause for a moment to note that your issuers that have only issued securities into the United States under 144A private placement exemptions typically would not be caught by SOX and the SEC rules. Now let's turn our attention to the Canadian response. Federal reform initiatives have largely remained at the consultative stage, with the only legislative changes being limited to minor amendments to the criminal code designed to strengthen corporate liability provisions. In Ontario, the most significant provincial government initiative has been Bill 198, which came into force, at least in part, in April of last year. Bill 198 has given the OSC broad authority to make rules regarding corporate governance standards and procedures, including CEO and CFO certification of financial statements, functions, responsibilities, and composition of board committees, and implementation of internal and disclosure controls. Bill 198 has also increased penalties for violations, including increasing the maximum penalty for securities law violations from $1 million to $5 million, and maximum prison terms from 2 years to 5 years less a day, increasing the maximum penalty for insider trading to the greater of $5 million or 3 times the profit made or loss avoided, increasing the maximum administrative penalty to $1 million, and creating a disgorgement remedy in relation to amounts obtained as a result of noncompliance with securities laws. As Phil Mohtadi will likely speak to, the provisions of Bill 198 that are not yet in force generally relate to the creation of a civil liability regime for secondary market disclosure. Now let's turn our attention to what our provincial securities regulators have done. Ironically, at least in my mind, the TSX took the lead in regulating corporate governance almost a decade ago when it sponsored the Day Report, where were the directors and subsequently adopted the recommended 14 practice guidelines, which can be found at section 474 of your TSX company manual. As the name would imply, these are guidelines. They are not mandatory. They are intended to be a flexible approach to corporate governance, and it is hoped that through the mandatory disclosure requirements in our information circulars, where we need to speak to an issuer's, or the issuer needs to speak to its corporate governance procedures as with reference to the 14 best practices guidelines, issuers will adopt an appropriate corporate governance infrastructure for them. While these policies, the TSX guidelines, currently remain in effect, so we can't lose sight of them, the TSX intends that they will be withdrawn and superseded by the proposed CSA multilateral instrument 58101 and policy 58201 that were published just this last Friday. So I intend to spend the remainder of our time on the proposed multilateral instrument and policy, as well as multilateral instruments 52108, 109, and 110, which were also published in final form just this last Friday, and subject to ministerial approval, we would expect to come into full force on March 30th. So like the TSX guidelines, the proposed multilateral policy contains best practices recommendations, including, among others, maintaining majority of independent directors, holding separate, regularly scheduled meetings of independent directors, appointing an independent chair or lead director, developing position descriptions for directors and the CEO, adopting a written code of conduct and ethics, and appointing a nominating committee and compensation committee comprised entirely of independent directors. The proposed instrument, 58101, relates principally to matters of disclosure and requires issuers to, or proposes to require issuers to, make disclosures in their AIF of their corporate governance practices, and in particular those practices recommended by the proposed policy, to file a copy of their written code of business conduct and ethics if it is adopted one, and to issue and file a press release if its board grants any director or officer a waiver from its code. So, like the TSX, the policy are recommendations. They're best practices. They won't be mandatory, but with the required disclosure required by the proposed instrument. My 2-minute buzzer did not go off.
Yes, there's something wrong with this, so just...
Wrap it up? Okay. I'll do my best. Okay. It's going to hope that market forces are going to force the appropriate infrastructure. So let me just quickly hit on what 52108, 109, and 110 are. 52108, auditor oversight. Essentially, this is going to require that any issuer who wants to have their financial statements filed are going to only be allowed to be filed if they are audited by an accounting firm that is in good standing with the CPAB, the Canadian Public Accountability Board. 52109 is the requirement for CEOs and CFOs to certify annual and interim filings, including AIFs, annual and interim financial statements, and MD&A. And that should take effect again on March 30, but it's a staged or staggered implementation, so I would point you to that. And lastly, 52110, which deals with audit committees, and that requires every reporting issuer to have an audit committee comprised of at least 3 directors, each of whom must be financially literate and, subject to certain exceptions, independent. I, again, have completely run out of time. I'm going to be pushed off the podium by Brian, but I would refer you to the written materials that contain far more in-depth discussion of each of these initiatives. Thank you.
Thanks, Jeff.
All right, we'll give this timer one more chance. The next speaker does have a PowerPoint. So I'm just going to, I'll set it up for him. Allan Goodman is a partner at Goodman's. No, it isn't his firm, but they did change the name for him. He's a former partner of Jeff and mine. Very, very significant experience, transactional practice. So again, it would be too easy to have him talk about some M&A topics. So we've given him probably the toughest topic of all, probably the number one question that lawyers get who practice in this area, the number one thing that'll keep you up at night wondering about your decision, and that is a particular issue material? Do you have to disclose it in an offering document? Do you have to issue a press release? There is no one right answer. Very, very difficult area, and Allan is just the person to speak to it. So, Allan, just get your presentation up here. There you go, just to the right.
Thanks, Brian. I won't have all the answers for you, but what I hope to do here is to guide you to the place where you might be able to find the answers. This area starts with some basic principles I think we just need to go over in terms of how this is evolving. It's the principle of equal access and a level playing field for all investors to have material information available on a timely basis. The concepts of material change, which we'll touch on from a securities legislative perspective, right now is considered as something that might reasonably be expected to affect the market price. We're talking about the market impact test, and we'll talk about some evolution in that area, as well as the requirement for listed companies to disclose material facts on a timely basis. And then the other principles at play here are the insider trading legislation, where there should be no tipping, and of course the premier principle in the policy we're going to talk about, no selective disclosure. Where do you go for this? Right now in Canada, CSA Policy 51-201, which was a response to the U.S. regulation FD, fair disclosure, came out in July of '02. The concepts of timely disclosure are laid out in there. There's an overview of the prohibitions against selective disclosure and guidance for determining materiality. The key point here is there is no bright line test, unfortunately. What the policy says is you should avoid taking an overly technical approach to determining materiality. It's very dependent on the company, its size, its business, the volatility of its securities, and the market conditions. The policy does list examples, but they're just that. They're examples. You have to review those in the context of your situation. The selective disclosure prohibition does have exceptions laid out there. The two that you'll deal with most are the necessary course of business exception. The idea here is that the policy is not to interfere with day-to-day operations. And so disclosure to vendors, suppliers, advisors, parties to a negotiation in the context of a private placement, that is an exception to selective disclosure, provided you there's an understanding the recipient won't then disclose the information, and that gets back to the tipping principle. The other exception is generally disclosed. Of course, the cure-all for selective disclosure is getting information out in the marketplace and disseminating it in a manner that gives reasonable investors time to analyze. And with the internet today and the distribution of press releases, this can be quite quick from the dissemination, but you have to account for the fact that investors need time to absorb the material. Simply posting information on a website, though, is not necessarily wide dissemination because people may not know to look there. The high-risk practices to avoid that are talked about are clearly analyst meetings. When your client calls you and says they're having a meeting with an analyst, the principle here is it's acceptable provided they're only reviewing the non-material and publicly disclosed information, which of course isn't what the analyst wants, but that's the danger in setting up those meetings in the first place. Earnings guidance is a big issue. Companies can't be selective in giving their earnings guidance. The move, as we'll see, is to put it in your MD&A now. You can give earnings guidance provided there's a reasonable basis for such statements, an appropriate statement of risks and cautionary language. The key, though, is it has to be updated when it changes, and you can't just leave the record showing some form of guidance when you know, based on some future event, that things have changed. The two cases to look at for principles, the Air Canada case a few years ago, blatant example of selective disclosure where the CFO authorized the announcement by phone mail on a Friday afternoon to 13 analysts that the earnings would be lower for the quarter based on higher costs. The stock dropped on the Monday by 14%, and only late in the day on Monday was a press release issued. And even then, that press release didn't have all the facts that the analysts had. The reprimand was $1 million fine along with other sanctions. YBM, which has a whole host of things in it, but one of the principles is that there was an audit suspension that the board knew about 18 days before it was disclosed. Clearly, the commission said that was a material change that should have been press released and announced, and it was one of a number of violations. So what do you do? What do you tell your clients? The policy sets out what the best practices here. Establish a written policy and process. This will include assigning spokespeople, setting out emergency plans if there's inadvertent disclosure. Set up open analyst conference calls. So have a conference call, announce it on the web that you're having it. You can invite the public. They don't have to have access to speak, but at least let them listen to what's being said to the analysts. Carefully review analyst reports if you're going to do it at all for the principles we talked about, only publicly disclosed factual information. Establishing a quiet period at the end of a quarter or year end where there's a moratorium on commenting on results. This will vary from company to company. Some do it at the end of a quarter, some only at the end of a year end. Insider trading policies and blackout periods have a senior officer responsible for vetting insider trading trades by insiders, and have a blackout period around the same time as the quiet periods to ensure there's no embarrassment, even if in fact the individual doesn't have inside information. And electronic communications, make sure that if there's a website, it's kept current, and to the extent information is distributed to analysts or investors, it should be posted on that website so everyone has access to it. Where you can look for other guidance, as I said, Regulation FD, which came out before the Canadian policy, is a stricter set of rules as opposed to guidance. There is an explicit prohibition on selective disclosure. However, they do have an exception if you do get a confidentiality agreement signed. There's also a 24-hour safe harbor in there for inadvertent disclosures, the ability to fix it by just making an announcement within 24 hours. Australia and the UK give us more along the lines of the Canadian approach of guidance, but again, those principles in there are helpful if you're looking for some more guidance. Finally, what's new? 51-102, the continuous disclosure rule, particularly the MD&A requirement, as I said, now talks about guidance in this context and what's helpful, so that's an important place to now look. The new certification rules clearly will help you establish processes, among other things, to deal with timely disclosure. The BC proposal on continuous market access to replace the prospectus system will obviously enhance the material information on a more current basis because you'll be required to do that as opposed to waiting for a prospectus. And the 5-year committee in 2003 had two principles that it was for consideration. One is to introduce the 24-hour safe harbor in Canada, similar to Regulation FD. The theory being that would be fair for those trying to comply with the spirit of the rules. The CSA has made no comment on that. And the standard of materiality that we initially started with, the market impact test, the US has a reasonable investor test. Would the reasonable investor consider it important to their investment decision, that information? This would be a fundamental change, and there's no indication at this point that we're moving that way in Canada. So this is an evolving area, although not as quickly as some of the others, but certainly, as Brian said, a difficult one for public companies and their lawyers. Thanks.
Thank you very much, Allan. Our next speaker is from the OSC and was principally responsible for a recent publication on MD&A guidance, one of the toughest areas of disclosure. So we really have the benefit of getting it right from the horse's mouth. So I'd like to welcome Mihkel Tang.
Thank you, Brian. Before I begin, I just want to say the views I express here are my own and not the views of the Ontario Securities Commission, nor for that matter, the views of other OSC staff. My topic today will be a 6-minute primer on MD&A. The importance of MD&A has been emphasized in a number of recent publications. The CICA published MD&A guidelines in November 2002. IOSCO published its general principles regarding disclosure of MD&A in February of 2003, and the SEC published an interpretive release on MD&A in December of 2003. This SEC interpretive release re-emphasizes the SEC's focus on MD&A and supplements the SEC's seminal release on MD&A published in 1989. To address its own concerns about MD&A, the CSA launched in early 2003 a review of how well Canadian publicly traded companies comply with their MD&A disclosure obligations. The British Columbia Securities Commission published a report in April of 2003. The Quebec Securities Commission published a report in October 2003, and the Alberta Securities Commission plans to publish a report in early 2004. Concurrent with the reviews in BC, Alberta, and Quebec, OSC staff reviewed MD&A of 47 companies that are subject to the MD&A requirements of OSC Rule 51501. OSC Staff Notice 51713, recently published last week and included in your packages, reports our findings. The main objective of our review was to assess compliance with the MD&A requirements of Rule 51501. Among other things, Rule 51501 requires reporting issuers above certain size thresholds to file annual MD&A in accordance with the requirements of Form 44101F2. I expect that these size thresholds will be eliminated in 2004, and all Canadian reporting issuers will have to file MD&A following the adoption of proposed National Instrument 51102. Proposed NI 51102 will require additional disclosure above the current requirements. However, I believe that the existing requirements will remain largely unchanged. More important, we believe that all of the deficiencies against the requirements in Rule 51501 that were identified in our staff notice would also be deficiencies under NI 51102. I also expect proposed multilateral instrument 52109 will be adopted at the same time as NI 51102. MI 52109 will require CEO and CFOs to certify that their company's filings, including MD&A, fairly present the financial condition of the company. Meaningful MD&A will be an important element of how companies achieve this fair presentation. In connection with our staff notice, I want to touch on one point of particular relevance for legal counsel. Of course, the devil is in the details, so I encourage everybody to read the staff notice. As set out in the staff notice, we found a number of companies with deficient MD&A. Though this is not the way we categorize the deficiencies in the staff notice, I want to divide the deficiencies for the purpose of this presentation into two general types. The first type of deficiency is those deficiencies for which I believe additional guidance on the form requirements would be helpful. For example, though Form 44101F2 requires issuers to disclose and analyze key value drivers, issuers may not clearly understand how to do so. By providing additional guidance, I believe the staff notice will help alleviate this type of deficiency. The second type of deficiency is those deficiencies for which I believe that additional regulatory guidance would not be helpful. This type of deficiency is a failure to disclose information that is clearly required by the forms. For these companies, the failure is not one of misunderstanding, but rather a failure to know what the requirements are. For example, one company we reviewed failed to disclose an item with a material impact on fourth quarter results of operations, as specifically required by Section 1.2 of Form 44101F2. There was no dispute that the information was material, nor was there any dispute that the information should have been disclosed. The company just missed it. Another company failed to disclose a default of a debt covenant and the anticipated method of curing that default, as specifically required by subsection 3.1F of Form 44101F2. Again, there was no dispute that the information should have been disclosed. The company just missed it. A number of companies also failed to disclose the selected quarterly financial information required by Section 2.1 of Form 44101F2. Now, this information is also required to be disclosed in the AIF, but these companies failed to even provide a cross-reference. Again, the companies just missed it. I don't know why these companies missed these items, but I do know one way for them to address the problem. These companies did not have appropriate processes or procedures for preparing, reviewing, and approving their MD&A. These companies probably did not seek advice from their professional advisors, like their lawyers, before filing their MD&A. In more than one of these reviews, legal counsel informed us that they had not had an opportunity to review the MD&A before it was filed. I think that legal counsel often became involved only when companies received their comment letters and we raised serious issues regarding a failure to meet the form requirements. As in many situations involving lawyers, that may be too late. I may be biased here, but I think lawyers should be involved. I'm not suggesting that lawyers draft the disclosure. It is, after all, management's discussion and analysis. However, I believe that lawyers should be involved because, fortunately or unfortunately, lawyers know forms compliance. And the fact is that many public companies, your clients, may not have even read the form, much less understand them. As we said in the staff notice, in this review, we often accepted commitments to make prospective changes. But going forward, it is increasingly likely we will ask companies to restate and refile their MD&A if they fail to meet the requirements. Be proactive. Make sure your clients meet the form requirements and stay off our errors and refilings list. Thank you.
Thank you very much, Michael. And just to reinforce the point that Michael made, the OSC does publish on its website the list of companies that have had to refile MD&A, so you definitely want to stay off that list. Okay, just to get caught up, I've cut a minute out of my presentation. The issue of securities law on the internet, you also can't do justice to it in 6, 7, or 8 minutes. It's, as a matter of fact, I'm probably not going to use that just because it looks like the animation was left on and we won't get through it clicking, so just ignore the slide. Why do we care? We care because just about every topic in securities law has some sort of impact with the internet. If we think about certain jurisdictional issues, very famous enforcement case out of Alberta, World Stock Exchange, was actually an exchange based on an offshore server, and then the question was, did the applicable Alberta legislation apply? In Robert Black's paper, he refers to the OSC settlement with 3 day trading securities dealers, Daytech, Ameritrade, and TD Waterhouse, where they had clients in Ontario, but they weren't registered in Ontario. So it's a standard registration issue, but the ubiquitousness of the internet, the fact that you can cross borders quite easily, just means that you're going to be tripping over what are otherwise standard procedures more often. The same thing applies with advisors. If you think about some of the financial portals that the SEC has been after, Money Central, AOL, Personal Finance, etc., are they advising? Are they not? There's an awful lot of content on those sites, and some might cross the line. So if we think about what the Canadian regulators have done, there are 2 national policies that were adopted in January of 2000, one dealing with the delivery of documents by electronic means, and the other one trading securities using the internet. Now, these don't change the underlying securities law substantive requirements, but rather clarify how those requirements are affected by this alternative means of distribution of documents or of consents. So in effect, what these policies do is they create a functional equivalency. So if I'm going to use an electronic medium, how do I comply with the policy guidelines underlying the old analog paper-based requirements? The policies, therefore, don't change the underlying securities law. They just clarify its application in the electronic environment. And that means if you have a pre-existing requirement, whether in corporate law or in securities law, that specifies a paper delivery, you may not be able to use an electronic delivery mechanism absent some sort of relief, blanket ruling, a new rule, etc. So how does it work if you're going to deliver something electronically? Effectively, and everything I'm telling you is in the very detailed slides you have, effectively you need the consent of the recipient. And if the recipient consents and you comply with the terms of that consent, they say, I have 5 email addresses, this is the one that I want to receive the prospectus at, and you comply, then it's acceptable delivery. The other policy, the one dealing with trading and jurisdictional issues, has a bunch of guidance, hypertext links, other materials on your corporate website. Are they incorporated in the prospectus? Are they not? How you conduct an electronic roadshow. And again, doesn't change the underlying substantive principles of the applicable securities law, but it just explains how they work in an electronic environment. Remember what I said before about the underlying law not changing? Think about the corporate statutes, which go back far before we had an internet. So many of the specific requirements, think proxy delivery, think books and records, think the ministry's books and records, have to be updated for an electronic environment. I'd mentioned before that where you have a requirement that specifically talks about a paper delivery or perhaps something happening in person or perhaps an original signature, that these national policies dealing with the electronic environment don't really help you. Those of you who hold stock directly or even indirectly might be familiar with the fact that we can now vote our shares electronically. We can now elect electronic distribution of materials through the broker-dealer that we're dealing with. And we can also vote by telephone. And if you actually open the material you get that we work so hard on to send out to you, you'll see that that's available now. Those are all available because of blanket rulings that have been published. Just very, very briefly, on the continuous disclosure side, National Instrument 54-101, dealing with communications with beneficial holders, has an electronic piece to it. They want to encourage it. The new continuous disclosure National Instrument 51-102, again, has a very small electronic piece in the companion policy, indicates that any document that it's talking about, and it's 288 pages long, can be sent electronically so long as you comply with the general principles in those national policies. So I'll end it there, and this is actually a great segue to our next speaker, Ross McKee. Ross is a partner with Blake Castles, practicing primarily in the area of securities. He had extensive involvement with Blake's assistance to the OSC in the policy reformulation project, and he's going to speak to us on the new continuous disclosure rule 51-102. Quite thick, as I mentioned. He's going to pick 6 or 7 specific issues to do in the 7 minutes available, and I'll turn it over to Ross.
No, I hate PowerPoint presentations too, but this way you only have to look at me once instead of 3 times, so.
Just left, right.
Okay.
Okay.
Thanks. All right. These are the 6 specialized topics that I plucked from the giant world of continuous disclosure obligations. Luckily for me, they all came from one new rule, so I was able to zero in on it. The new rule 51-102, this describes a rule. This is the rule. It's really a book rather than a rule, but it's all there in one spot. And the idea is that the rule is going to harmonize disclosure across Canada so that we will have one set of disclosure rules across Canada, not varying by province. And this one is, in fact, actually national. There are still a few provinces like British Columbia and Manitoba that have exempted themselves from different pieces of it, but it's largely national as opposed to being multilateral and so on. The rule's already been made, but it's going to become effective March 30, 2004. However, some prior work needs to be done in advance for preparation of that. The rule does not apply to investment funds. It only applies to reporting issuers that are not investment funds. There is a distinction made between venture issuers and other, i.e. senior issuers. And venture issuers are defined in the rule as being a reporting issuer, first of all, with no securities listed or quoted on either the Toronto Stock Exchange, NASDAQ, U.S. national marketplaces, or any marketplace outside the U.S. or Canada. So what it boils down to is if you're listed in the TSX Venture Exchange, you're a venture issuer. If you're a reporting issuer in Canada and you're not listed anywhere at all, you're a venture issuer. If you're listed on the Toronto Stock Exchange, you're not a venture issuer. And venture issuers get some breaks and exemptions here. For example, they don't have to do AIFs. Financial statement timing, first thing of sort of moving things and accelerating reporting. The regulators recognize that after all this time, people can actually figure out their financials faster than they used to, and so they move them forward. In general, and this particular rule, this subset of the rule, this applies to issuers with financial years starting on or after January 1, 2004. And notice that's financial years, so it isn't, the rule comes into effect and it applies to all issuers from then on. It's only if your financial year starts on January 1. So if your financial year end was December 31, 2003, the new rule applies to you next year. The acceleration part comes, annual financial statements have to be filed 90 days instead of 140 days before the year end for regular issuers. Venture issuers, still faster, but not quite as fast, 120 days. Interim filings, 45 days faster instead of 60. Venture issuers still left at the old 60 days. In each case, you have to file them earlier if you've filed those financial statements earlier in a foreign jurisdiction. So for example, if the United States accelerates their rules to say you have to file your annuals within 60 days after your year end, you will then have to comply, when you comply with the US rule, if it's applicable to you, you would have to also file your Canadian statements at the same time as you filed them in the US. The new MD&A form. Michael has already scared you for me, so you'll be paying attention in this section of it in particular. They said the form and the instructions just brings together the various pieces, makes it uniform, and adds a few enhancements. This is in the staff's notice for that. The enhancements have expanded the rule from a 5-page form to a 16-page form. And it's much, much more involved than it used to be. And it's clear that the MD&A has become the signature document, no longer the long-form prospectus. The MD&A is expected to be the core document, every issuer's disclosure. Just to make life complicated for us, the materiality threshold in MD&A is stated within the instructions not to be the same as it is in the rest of the Securities Act, material fact, material change. They refer instead to the materiality as used in the CICA handbook, which is more like the reasonable investor standard. Would it affect your decision to buy or not? And so it's a whole different standard materiality that's used when they say, is it material? So in fact, you have to bring both standards to apply. You can't reach a material fact, and you also have to satisfy the form requirement to use material the way they mean it in the form. The form calls for use of plain language as far as possible. And there are a number of new items that are in the form that have not been there before. And all I can do in the time is list them to draw your attention to them. For example, use of proceeds report. You have to, if you said in a prospectus we're going to use it for this, you have to later in your MD&A say, well, we didn't actually use it for that. Or we're trying it, but the project's farther behind. Much more discussion about the factors affecting the business of the company. A table of contractual obligations, when things are due, like 5 years ahead, even farther. Off-balance sheet arrangements, very clearly a post-Enron type of disclosure. More information on related party transactions, fourth quarter proposed transactions, not even ones that are happening yet, but they're proposed. Critical accounting estimates, which our clients are telling us is in fact going to become a critical disclosure item for them because it requires them to use the phrase open the kimono and give details about what estimates they use in their various numbers, which can be very important on pricing and so on. Changes in accounting policies, and then a whole lot of discussion about financial instruments and non-financial asset instruments. Transitional MD&A. This is one of the important factors that I want to highlight for you because it may require immediate action. One of the rules is that if the first interim MD&A that is filed using the new form, if the first MD&A filed under the new form is an interim MD&A, not an annual MD&A, that first interim MD&A must still have all the annual MD&A information built into it. And the idea is because interim MD&A is supposed to update as it goes forward. So they're saying, well, you have a whole new form, so you have to therefore put the whole new form into the interim MD&A. Therefore, the staff have said if your year end is December 31, 2003, technically for the last financial year, you could file your MD&A in 2004 using the old form. Right? You'd have until May 19, the old timing and so on. But you'd have to file your new MD&A by May 15 in the new form. So they're saying, it makes sense to you, and we've actually changed the old requirement retroactively so you can file your MD&A in respect of the 2003 financial year using the new form, and therefore your quarter 1 2004 MD&A will in fact be only an update from the MD&A you gave in respect to financial year 2003. If you're confused, there is a staff notice that says that, and I think just about the same language, and it's referred to in my paper. But it basically means that you should probably be doing your MD&A for 2003 using the new form, even though it's not necessarily due until the following year subsequent. Another major change that's come into the new rules is the business acquisition reports. These are a concept imported from short form prospectuses and have given many of us heartaches when doing that. Basically, if you do a significant acquisition, and there's a very complicated definition for determining what's a significant acquisition, you have to include reports and financial statements going back for that company, pro forma financials, and so on. The new rule will apply for binding agreements entered into on or after March 30, 2004. So for example, you will need to think in closing conditions the right to have financials reported on by auditors of the acquired company used in the acquiror's financials going forward and securing the necessary auditor consents, that sort of thing. There are exemptions if the information was already covered in an information circular within the previous 9 months and there's been no material change. Two last points very briefly. You have to report voting results now, and the rule requires that you disclose the results of votes, including the actual ballots if there was a ballot. And we know that Fairvest is already calling clients, asking them for information for last year, even though the rule isn't even in effect yet. And filing material contracts. I was jumping ahead for a second. This looks very novel and very strange, but in fact, it's just basically they're supposed to be the same list of material contracts that issuers report in their annual information form in item 15, but you actually have to file copies of them. There is some exemption for blacking out particularly confidential areas and so on, but it's going to be a requirement. And you also have to set an initial record of filing things like bylaws and shareholder agreements, which haven't previously been public before. And one last bonus extra point, because I couldn't decide which was the sixth most important. If you already have exemptions from continuous disclosure rules, those exemptions carry on. They don't automatically all die. But the first time you use them, you have to tell the staff, here's the old exemption we used to have, here's the new rule, here's why we're still relying on the old exemption just so you can update your records and so on. And so you can still use them, but you have to basically highlight the fact that you are using them. You can't just make it automatic.
Thank you very much, Ross. Our next speaker, Phil Mohtadi, is a very experienced practitioner, partner at Tories, dealt with Phil for many years, and his experience is far broader than the very modest background he's given in our binder. I'll just get Phil set up here. Okay, following up on Ross's presentation, Phil's going to speak to us about incoming civil liability.
Thanks, Brian. Good morning, everyone. In the past, when Brian and I have worked together and we've had 8 minutes to do something, he's usually taken 7 minutes and 45 seconds and left me with 15. So I've finally managed to turn the tables on him. I'm going to talk about civil liability for continuous disclosure, and if time permits, a brief 1 or 2 points about the new certification requirements that you've heard about previously. The status of the civil liability provisions is that they were passed last year as part of Bill 198, but they were not proclaimed in force pending some technical amendments in Bill 41. Those amendments were not passed as a result of the change in government, but are expected to be reintroduced this spring, and we expect that the changes will be proclaimed and in force sometime shortly. The stated purposes of the civil liability regime are to improve the quality of continuous disclosure, to redress the disparity between primary and secondary market transactions, where, as you know, the bulk of trading occurs, and eventually to facilitate a move to an integrated disclosure regime and harmonized disclosure between primary and secondary markets. And indeed, the OSC has a concept proposal out on integrated disclosure. There are 2 types of violations. There's a misrepresentation in a document, which is a written communication filed with the Ontario Securities Commission or a government agency, or a misrepresentation in a public oral statement, and a failure to disclose material changes on a timely basis. As you would expect, in terms of who can sue, the right is granted to people who buy or sell securities during the period of the violation, when the misrepresentation is first made or the failure to make the timely disclosure occurs, and when it's corrected. Now, it's expected that other provinces will eventually follow suit and pass legislation similar to Bill 198, but it's not likely to occur in the near future. But nevertheless, it's expected that plaintiffs outside of Ontario or outside of Canada will be able to avail themselves of the legislation should they wish. In terms of who can be sued, depends on the type of violation and the status of the person who commits the violation. For example, whether the person is an inside or outside director. And in terms of the list of potential defendants, it's the usual suspects, including influential persons who are control persons, promoters, or insiders of the issuer. Turning to the burden of proof, one of the important aspects of the legislation is that it's not necessary now for a plaintiff to demonstrate reliance on the misrepresentation or other continuous disclosure violation. Formerly, at common law, when plaintiffs brought actions for misrepresentation, they had to demonstrate reliance, and that was often made it very difficult to bring an action, particularly a class action. But that's now changed in the legislation. The burden of proof varies depending on the nature of the violation and the type of dependent. And so documents are classified as core documents, which are the principal disclosure documents of the company, and non-core documents, which are other written communications. So, for example, in a core document, a plaintiff doesn't have to demonstrate that the defendant had knowledge of the misrepresentation. That's not the case for non-core documents or public oral statements, where, with minor exceptions, the plaintiff has to demonstrate that the defendant had knowledge of the misrepresentation or was guilty of gross misconduct. Similarly, in the case of a failure to make timely disclosure, a plaintiff doesn't have to demonstrate knowledge against the issuer or officers of the issuer, but does against any other defendant that they had knowledge of the failure to make the timely disclosure. All defendants will have a due diligence defense. Must be able to, in order to avail themselves of that defense, must be able to demonstrate that they undertook a reasonable investigation and had no reasonable grounds to know of the violation. The legislation itself sets out various criteria that the court can look at to assess whether the defense has been met, including, I think most importantly, the type of systems that the issuer had in place to ensure that its continuous disclosure obligations were met, and the reasonableness of reliance on those systems. There are also a number of other defenses available in the legislation, including the plaintiff had knowledge of the misrepresentation or material change. There are provisions in the legislation to assess damages. There are complicated formulas which apply depending on the time of the sale or purchase of the security after it's been acquired or sold during the violation period, and the amount of the loss will depend on when it's sold or indeed whether the security is held. You can only recover based on the rules in the legislation, and if the loss is caused by something other than the continuous disclosure violation, you're not entitled to recover from that. There are liability caps to limit the liability of defendants, which in the case of individuals is based on the amount of compensation it received from the issuer during the last year. One of the concerns about civil liability from those people who commented on it was that it would encourage frivolous suits by entrepreneurial lawyers and business people trying to extort money from issuers. And so one of the ways that the legislation attempts to meet that concern is to require that plaintiffs obtain leave from the court before they can bring an action, and they must be able to demonstrate a reasonable possibility of success, and any settlements also require court approval. Perhaps just finally, there are many practical issues raised by the legislation, and it's incumbent and important for issuers to establish appropriate disclosure control policies. We expect that issuers should have a written disclosure policy which identifies who can speak on behalf of the issuer and establishes a process for the review of public statements and whether there's been a material change. We also think it important that there be an establishment of a disclosure committee which would be responsible for those control policies and ensuring compliance with those policies. And again, issuers may like to set up procedures to review and vet core documents the same way that they would review prospectuses now before filing. And finally, given the fact that issuers will be liable for failure to disclose material changes on a timely basis, we expect that there will be a greater use of confidential material change reports when negotiations are ongoing and before a transaction is announced. Thank you.
Thank you very, very, very much, Phil. This is going to be an area of intense scrutiny and litigation once it gets enacted. There's a very narrow slice of direct professional liability in the Bill 198 construct. Basically, if you would have a written consent to use a report or conclusion of yours in an offering or continuous disclosure document. So that's kind of a narrow subset of what we do every day, which is just give advice and have our clients rely on it, including some of the tough issues you heard today. Our next speaker, Bill Pepall, who's a partner with Heenan Blakey, has developed a practice focusing on the issue of class action litigation, professional liability, and he's going to speak to us about professional liability in this area for our advice on some of these tough issues. Bill?
Thank you, Brian. My remarks will deal with some existing liability risks and some potential liability risks in the event that Bill 198, the Bill 198 amendments are proclaimed in force. The first risk that I'd like to talk about is the cross-border risk. You know and you've heard that many Canadians raise capital in U.S. markets, and these companies are often listed on U.S. exchanges. There are, to be sure, benefits in accessing U.S. capital markets, but there are risks and burdens. Canadian companies who participate in cross-border issues expose themselves and their service providers to the U.S. securities law and enforcement regime. And U.S. securities private law civil litigation is something that we're not used to here. The defense costs are enormous, and you have to factor in jury risk. The plaintiff's bar in the United States is well organized, it's well financed, and it's motivated by contingency fees. They're supported by qualified experts, and they'll go to the jury and write a large number on the blackboard. Defense counsel addressing the jury may be required to make an argument that something to a jury of perhaps in a rural American community that $50 million isn't material. Cross-border transactions mean that you can be transported from the peace and tranquility of your Toronto office to become a character in a John Grisham novel. I know from personal experience defending professional service firms in U.S. litigation, our U.S. attorneys tell us, you will need a jury consultant, you will need a dress rehearsal jury, and you will need a shadow jury to watch the proceedings every day. That's why most of these cases settle, because the jury risk is very difficult to measure. Auditors routinely face this risk because when they issue audit opinions on the fairness of financial statements, they expose themselves to this type of liability. In Canada, despite the number of high-profile failures that we've seen that involve disclosure deficiencies, we have not seen a lot of this type of litigation. And I think there are essentially three reasons for it. The first one is the reliance requirement. In the absence of a statutory cause of action, the Queen Incogno says reliance is a substantive element of the cause of action. And that's very difficult for plaintiffs to prove, and it pretty much knocks out of the box the class action form of procedure because reliance is going to be an individual issue. The second thing is the Supreme Court of Canada decision in Hercules and Ernst & Young. Even though they're the shareholders' auditors, even though they've got a statutory obligation to audit, even though they have to be independent, even though they have access to information, the law is that the auditors do not owe a duty of care to the shareholders in giving advice or informing them on their investment decisions. So it's hard to mount one of these cases if you don't have a claim against auditors. The third one is the loser pay cost rule that we have here. You take the first two risks and you add loser pays costs, and those are pretty much substantial obstacles or impediments to litigation. They don't exist in the United States. Under Section 10B and Rule 10b-5 of the 34 Securities Exchange Act, you have a statutory cause of action for secondary misrepresentation. The reliance requirement is dealt with, at least to some extent, by the presumption that the fraud on the market gives you. So that's why you have that active litigation scenario in the United States. You don't have it as much in Canada. Bill 198, if it is passed, if it's proclaimed in force, will change that. It will remove the reliance requirement. The cause of action is there, quote, without regard to reliance. Insofar as experts are concerned, the definition of experts under that act includes lawyers, accountants, actuaries, appraisers, auditors, there goes Hercules, engineers, financial analysts, and geologists. Liability may arise when there is a misrepresentation contained in reports, statements, or opinions made by experts, or when the expert consents in writing to the use of the expert's report in a statement made by another, provided the misrepresentation is not made knowingly. Liability is proportionate. That's been a big issue. Joint and several liability has been a real problem for professional defendants, well-funded professional defendants. It means the plaintiff's collection problems become your collection problems. But the liability under this new act will be proportionate. And for experts, as it has been said, the cap on damages is $1 million, or the greater of $1 million, and the amount of revenue earned in the previous year. Those protections, proportionate liability and the damage cap, disappear if the misrepresentation was intentional, which will be unlikely in the case of an expert. But we don't know how the courts are going to interpret knowingly, and you may see the U.S. case law on scienter, the scienter requirement in 10b-5 come into play, and you'll see something like recklessness or gross negligence become a factor. My real concern for professionals in Bill 198 is the third-party risk. There's nothing to prevent the issuer from instituting a third-party claim for indemnity against the expert. The issuer is sued for a continuous disclosure violation. An aspect of the issuer or the director's defense is, we relied. We relied on our lawyer. We relied on our auditor. We relied on an expert. And in addition to that aspect of the due diligence defense, the issuer or the director or officer institutes a third-party claim. In that event, arguably, potentially, the professional's liability cap, or the liability exposure, is the liability cap of the issuer, let's say. And the issuer's liability cap can be 5%, the greater of $1 million, or 5% of market capital. 5% of market capital of one of the Canadian banks is a huge, huge sum. So there are definite issues of concern for professionals in Bill 198, but it will introduce a certain parity between the secondary market situation and the primary market situation, where we already have a statutory cause of action for prospectus misrepresentation where reliance is deemed, and there is a due diligence defense. My paper addresses the regulatory liability, and I refer you to the Wilder case and the jurisdiction of the OSC to utilize Section 127 to discipline lawyers representing clients before the OSC. Thank you.
Thank you, Bill. Bill's comments have reminded me that when we do this program again, we're going to add one paper on judgment proofing. And it's something that I'm sure will grab everybody's attention. It did, by the way, come up in some of the litigation related to one of those failed installment receipt deals that you heard about today, where everybody had kind of moved their installment receipts into some shell vehicle, and when there was a secondary transaction, when the principal shareholder went to collect on the installment receipts, they had a bunch of empty IOUs. So we'll definitely focus on judgment proofing next time. Heather Zordell is our next speaker. Heather, we don't have a bio in the materials, but suffice to say she's a very experienced practitioner. She's going to speak to us about takeover bid and issuer bid regulation.
Did you get that in here?
No. Did they load it? Let's see. Okay. Okay.
I lost my loaded. Okay.
Hi, I'm Heather Zordell, and I'm going to cover substantial issuer bids today. The topic I have is takeover bids and substantial issuer bids, but I've narrowed it down a little bit because of where we are in the economic cycle. Right now we're at a position where, last few years you haven't been seeing as many takeover bids, partially because companies' currency is considered to be at too low a value, so people don't want to be using their stock to buy something else. But what we are seeing is that companies are getting into a better financial position. They are, their trading prices are right now being perceived as being low, and they're looking for opportunities to improve their balance sheets. So a substantial issuer bid is one place where that can be done quite effectively. If you've got some sort of outstanding security, particularly such as a convertible debenture, that you might be able to buy back at, could be trading at, say, 59 cents on the dollar or even up to 80 cents on the dollar, it could be a good value. You notice I'm not going to talk a lot about buying back an issuer bid for common shares, and that's not covered in the materials that I gave you, but the principal reason for that is that the various corporate statutes have some restrictions on buying back shares. And in particular, from one of the slides, we had section OBCA section 30 sub 2, which says that a corporation shall not make a payment or purchase or otherwise acquire securities issued by it where there's reasonable grounds for believing that the corporation would be unable to pay its liabilities. That one you might be able to meet fairly well. B, after the payment, the realizable value of the corporation's assets would be less than the aggregate of its liabilities and its stated capital for all classes. Stated capital is sort of the problem area that a lot of companies run into, particularly if they were issuing securities along the way in the boom markets and the stock prices have dropped significantly. Their stated capital may be actually too high to make an issuer bid at this point. And while they can adjust their stated capital, that has some other accounting implications. So let's talk about substantial issuer bids. We're looking at a sort of a convertible debenture where you might want to buy back some securities, and you often will need an exemption from a valuation to do that, because you're buying back your securities. Securities regulation says you've got to either do a valuation or somehow have an excuse for not doing it. The exemptions are available if you've got some sort of a convertibility feature that is determined to have no material value. And that becomes sort of an interesting thing. Why would a convertibility feature have no material value? If your stock price is trading really low. In other words, the conversion was set at $5 when the stock price was trading at $5, and you thought it was going to go up, but it subsequently went down instead. So now you're trading at $1. No problem, you can meet that test. Another test would be that the securities trade on an exchange like a non-convertible, that they're sort of an unsecured debt based on the issuer's underlying creditworthiness. Again, if your stock price is down, your convertibility level was up high, your stock price is here, then you can quite fairly easily say that your debentures are trading on the basis of debt. And then the other reasons would be if the debenture holders can evaluate the offer based on the information in the market. If your securities are listed, that's probably the case. The cost would exceed the incremental benefit, and the offer would provide immediate liquidity. Of course, as soon as you make a substantial issuer bid, that is providing liquidity in itself. So really, two things you got to say is that your convertibility feature has no material value, and your securities are trading on the base of the underlying company's creditworthiness. And then what you do is you get a dealer on side to give you that opinion. Not much of a problem, just takes a little bit of money. If you're doing a substantial issuer bid, what do you need? A circular, of course, and the materials I gave you sort of set out the long form requirements for doing that. But you're explaining your bid procedure, you're explaining why it's good for the company, your price history, your tax implications. Why do we do tax implications? Basically, it's just a sales pitch to tell people that this isn't going to hurt them. And then you're going to talk about the payments you're making, and you're going to attach that dealer opinion. So those are the mechanics. The The other thing I wanted to talk about today was book-based securities and how they factor into all these things. It applies both to takeover bids and to substantial issuer bids. As we're moving along, we're seeing more and more securities are being issued on a book-based only system. And that's it's just the way of the future. Companies are trying to avoid having to deal with certificates. It's maybe not so appropriate for common shares, but it's certainly appropriate for a lot of other securities that you're going to issue. So we had one recently with Basis 100 Inc. It's referred to in your materials if you want to grab that circular off CDAR. It's very useful. It's the first time that I've really seen where some effort was really made to establish some procedures for that. One of the things you don't need is you don't need a guaranteed delivery procedure. So if you've been used to standard, is that 2 minutes? Nope, that's 2 minutes. If you've been used to your standard takeover bids and issuer bids, one of the things you always have to deal with is this guaranteed delivery procedure where if the person can't find their certificate, they can sign a form and say, oh yeah, we'll deliver that, we'll deliver it later if we find it or if maybe it's lost. And that procedure just goes away because you couldn't possibly have mislaid the certificate. It's only one certificate and it's held by CDS. Another thing you don't need is, obviously, you don't need to send a letter of transmittal out to people because, again, the only person that's going to have to transmit anything is going to be CDS itself, which will hold the global certificate, and they just have to deliver that certificate back to the issuer with their tender. Another thing that's different about book-based securities is that you have to sort of change the timing for your issuer bid because of a couple components. One is that CDS is the one that actually makes the delivery. So what happens is the dealers just sort of collect all the interest. If you're a security holder and you want to tender to the bid, you just call up your broker and say, yeah, I'd like to tender. Then the tender tells his back office, the dealer tells his back office, and then the dealer collects them all together and makes one tender at the end of the bid to CDS. CDS collects them all up and gives one final number to the issuer. That means that just for CDS procedures, you can't have a bid expiring at 5 o'clock in the afternoon. You have to have it sort of work its way through the system in the morning, and your bid actually expires earlier in the day. And it also means, just because of trying to keep all the regulators happy, that you end up having a 36-day bid instead of a standard minimum 35-day bid, and that's because the securities regulations were drafted on the basis that you would have a minimum 35-day bid, and since we're saying that you have to get your tender in a little bit early, they say, well, why don't you add an extra day to that? So that's it. It's a interesting procedure. If you've got some clients that have got securities out there that are undervalued right now, you can take a look at it and have some fun.
Thank you, Heather. Our next speaker, Frank Allan, is partner at Borden Ladner Gervais and head of their Securities and Capital Markets Group. Frank has some experience out in Alberta and, of course, is known to many of us as a former general counsel of the OSC. He's been a member of SAC for years as well, certainly a leading practitioner, and he's going to speak to us about a topic that is always considered sexy, offensive and defensive tactics in the context of takeover bids. Frank? No, they didn't load that.
There are a deck of sheets that were in the side pouch in my binder. What I propose to do is quickly move through a number of these points. What I've tried to identify are some of the factors that are relevant in terms of trying to complete a successful takeover bid transaction or conversely respond successfully to an unsolicited takeover bid. One of the areas of particular interest and intrigue with takeover bids is the objective of the exercise. And from the point of view of the bidder, in economic terms, it's like any purchase, the maximum amount for the least amount of consideration in terms of a value proposition. Alternatively, from the point of view of the target company, It sometimes takes a while to convince the board that short of illegality or other qualitative considerations, at the end of the day, the shareholders will get to decide in Canada, and it will be a matter of price. So the exercise can follow any number of alternative decision trees, but at the end of the day, I guess one proposition that we find in the Canadian takeover bid environment is that shareholders do get to decide, and that's one point of distinction with the U.S. precedents. There are U.S. precedents, albeit few in number, which conclude that a board of a target company may, in certain circumstances, frustrate the ability of shareholders to respond to a transaction. From the point of view of a bidder, probably the most important tactical advantage that they possess is timing. These are complex transactions typically, and bring to bear a myriad of disciplines and strategic considerations. So planning is absolutely critical, particularly in the context of an unsolicited transaction. And in terms of planning considerations, there are a number that are internal as well as external. And one of the most important ones is the internal financial analysis and the establishment of parameters, boiling down to how much can the bidder afford to pay and still have an accretive or positive transaction from the point of view of the bidder itself and its stockholders. And in the robust M&A markets earlier, or in the last decade, in the late 80s, there's any number of examples where bidders with 20/20 hindsight went too high and were not able to, at the end of the day, justify the acquisition and subsequently ran into trouble. That exercise is a very important one. In my experience, it's one that is done best at the beginning, before there's any emotion, before the media, before shareholders get involved. So the setting of corporate objectives, the organization of an internal team, it sounds trite, but it's critically important in terms of experienced advisors, and I'm not thinking only of legal advisors, financial advisors, accounting, public relations, government relations. The ability to organize the bidder's team, have everything orchestrated, the timing of the transactions, very important. There's also the analysis of the target, any particular regulatory issues, the structure of the target, the existence of a rights plan, various considerations. A number of the new corporate governance initiatives I think are going to be relevant in terms of looking at the disclosure record, because one of the realities going forward is with the quarter following the acquisition in a negotiated or an unsolicited transaction, the financial results of the target company will need to be certified by the CEO and CFO of the acquirer. And the ability to try to understand these certifications, and if there is diligence provided, work with the procedures and understand them, may be invaluable in giving those two individuals comfort when it comes time to sign the certificate in the quarter following the acquisition. The transaction itself, the structure that it'll follow, obviously the takeover bid is the familiar route. Amalgamation transactions are pursued depending on tax and other considerations. For instance, the proposed Manulife John Hancock transaction is a U.S.-Delaware merger. The proposed Moore-Wallace transaction with R.R. Donnelley is being done as an arrangement under the CBCA. These are important considerations. If you're going the bid route, one issue to be considered is whether you acquire a toehold prior to launching your transaction. This has implications if you're offering share capital as part of your consideration. If it's a straight cash bid, it's a more straightforward consideration due to the pre-bid integration rules. And needless to say, if you're looking at a partial bid, you want to be extremely careful in terms of carrying out any pre-transaction accumulations. There's also the question of disclosure and early warning reports. At some point in the process, there will be negotiation with the target in all likelihood, If it's a friendly transaction, there'll be an approach on a quiet basis. A number of agreements will be considered in the normal flow. Confidentiality agreements, one of the key provisions there is a standstill, whether that is something a bidder is prepared to accept, which basically binds the bidder to working with the company, and if they're not able to come up with a mutually attractive transaction, stepping aside. As well, an acquisition or a support or a combination agreement where you get into reps and warranties by the target company in favor of the bidder. You might have a material adverse change condition to the transaction. And some of you may remember the Tyson battle for a pork producer called IBP, which went to court when Tyson tried to get out of its acquisition of IBP on the basis of material adverse change. And the court took a very narrow view of the material adverse change provision in that agreement, and it's been interesting over the intervening 3 or 4 years to see the development of material adverse change clauses now, where there are specific carve-outs for general economic change, general industry change, announcements of that deal in particular causing an effect, and in some cases indicating that simply a change in market price will not be regarded as a material adverse change. In the US, there was a decision last year, Omnicare and NCS, which highlighted the importance of directors of a target having a fiduciary out to respond to a superior offer. So if in the process a superior financial offer comes to the target company, in both Canada and the US now, the better practice, and in Delaware, the required practice is for the board to have a fiduciary out to consider that offer. Lockup agreements with significant shareholders are very important in terms of supporting the transaction. As a result of the Zimmerman amendments, you're now able to start a bid by mailing the document or publishing an advertisement in the paper. Certainly the publishing the advertisement route gives you even a greater timing advantage in that you don't have to seek out the names of the target shareholders. Tactically, the use of the courts and the regulatory commissions will be important. On the defensive side, special committees are typically used if only for logistics. These transactions are extremely time-consuming. Committees are required to meet many, many times over the course of a 35 to 45-day bid, leaving aside concerns about independence and conflict. A special committee for logistical reasons is critically important. I touched on the importance of advisors. Unit holder rights plans still have a role to play, particularly if they have been approved by shareholders or are approved by shareholders on an expedited basis. You're going to get into the financial analysis of the bid, whether it's adequate, whether it's a fair transaction. And then the ultimate response, just say no. We've had an isolated number of cases in Canada where the target has basically said to its shareholders, we recommend you turn this down. It's not adequate. You can do better by staying as a shareholder. Slocan and Canfor is one example. By far the norm is a white knight process, and you may well end up with the original bidder or with a white knight, or you may have a tug of war between them. And at the end of the day, the shareholders are given the opportunity to respond to the best offer. On the last page, I've just touched on 3 or 4 sort of interesting things that have struck me looking back on last year. First of all, the CSA notice about true offerors. Use of wholly owned subsidiaries now requires the parent to sign the circular. The CGI transaction in Quebec was very interesting on a disclosure point. Apparently the CVMQ was conducting an investigation of Cognacase, the target, but in connection with the investigation, they issued an order prohibiting disclosure, and the CVMQ only permitted Cognacase to tell CGI, the unsolicited bidder, after it had signed a support agreement. And it's a very interesting development in terms of if you're carrying out diligence, how do you frame a question that would elicit the answer that would give you some idea that the CVMQ is conducting an investigation of your accounting when they're under a prohibition order? and the CVMQ is comfortable waiting a month in the face of a publicly announced transaction being covered daily in the media and not having the target be able to tell the bidder that the investigation is being carried out. Insider trading, most of the media articles focus on the run-up in share price before M&A transactions. The Alberta Commission has been particularly aggressive with individuals, be they advisors in the first case, the Agrawal case, be they directors in the case of Mr. Harris and Mr. Cito. Once again, it's incumbent on management and advisors to target companies as well as bidders to ensure everyone is sensitive to the inability to trade on undisclosed material facts. And lastly, this case that I've cited in New York was an instance where somehow the lawyers, in corresponding with each other, basically sewed up a transaction so that the share purchase agreement was regarded by the court as a binding agreement without the execution of the agreement by either party. So it's just a warning, a red flag in terms of correspondence between counsel to be very careful and cautious in terms of limiting the effect of those draft agreements, those unsigned agreements.
Thank you very much, Frank. Okay, we have our last speaker. Thank you very much for bearing with us. And I think it's kind of remarkable after all that we're really only about 10 minutes behind. So I want to give Jim Doris, who's a partner in the litigation section at Davies, full allotment of time. He's also going to speak to us about a very, very topical, interesting issue, and that's the litigation in the context of takeover bids, going private transactions. This is something that you see all the time where there's a squeeze out and particularly the institutional shareholders don't like the price. They want to challenge the valuation. Jim has experience in many of these situations and played a leading role in 2 of the cases that we study all the time, Pacifica Papers and Ainsley Financial. So I'll turn it over to Jim.
Well, hopefully we saved the best for last. There are actually very few cases where these types of transactions get litigated, and I think there's a couple of reasons for that. One is that companies don't generally proceed without knowing that there is substantial shareholder support, and as you'll see later, that issue becomes directly relevant to the sort of recent case laws where the seeking of support has given people who want to challenge a transaction a ground to do so. The second reason you don't see a lot of these cases is they're very difficult to challenge. Courts are defer to the shareholder vote, and given the business judgment rule, do not lightly second-guess boards. And the exercise is largely, if you're trying to uphold a transaction, to try to maintain the benefit of the business judgment rule. So you have to show that you've acted independently, free of conflict, you've acted rationally, reasonably. And if you can do that, and you've got an evidentiary record to support that, it's very difficult for someone to challenge a transaction. And in fact, in most of the cases that you see, the person challenging the transaction is not normally just a disgruntled shareholder, but it's a disgruntled shareholder who also wants to be a bidder. And in those cases, that shareholder has an incentive to do whatever it can to upset the transaction and raise as many possible attacks as it can to either delay the transaction, make it more expensive for the other bidder, and increase the price that they will receive as a shareholder. On the flip side, if you're seeking to attack a transaction, what you have to do is to defeat the board's ability to rely upon the business judgment rule. So you have to try to attack it on the basis that the board has a conflict. The board didn't act independently. The independent committee was not independent. The advice the board relied upon was faulty, or the board did not consider the advice properly. And the alternative to that, or along with that, and you'll see in these cases, is there's usually a kitchen sink approach where the person attacking the transaction raises every possible attack. And the other really key area to attack is legitimacy of the shareholder vote. And there's a couple of recent cases in BC where the ability to attack the shareholder vote, the legitimacy of it, the legality of it, have now been front and center, and these cases make it much easier and much more likely that you'll see in Ontario in the next couple of years attacks on these types of transactions based upon an illegal shareholder vote. And the first case, and these are covered in my paper, the first case is a SEPS case, which is a BC Court of Appeal case in 2002. And in that case, there was a 12% shareholder who signed a letter of support in favor of a transaction which was proceeding by way of plan of arrangement. And at the lower court, this was a going private transaction, the lower court held that that shareholder's 12% vote did not have to be excluded from the majority of minority calculation. Went to appeal, the Court of Appeal disagreed, and the Court of Appeal held that a shareholder who signs a support agreement or indicates his support prior to the mailing of the circular is acting jointly or in concert with the acquisition group. And as a result of that, that shareholder's shares had to be excluded from the majority of the minority calculation. And the effect of doing that in the SEPS case was that the arrangement did not meet the statutory thresholds of the BC Company Act. And in the SEPS case, you'll see in my paper, the court expressly refused to follow the OSC policy, which had held that it wasn't sufficient to simply sign a support agreement to find that they were a person was acting jointly in concert, provided that the shareholder was not receiving any consideration other than or what was identical to the other shareholders. The court looked at the OSC policy, said it didn't apply in BC, refused to follow it on policy grounds, and held that as a matter of fact, a shareholder who signs a support agreement in advance or a letter agreement in advance of the mailing of the circular is acting jointly or in concert. The court also said that if the company sought the support after the circular had been mailed, the person would not be acting jointly or in concert with the acquisition group. So that's the SEPS case. The other case that will have consequences here in Ontario is the Pacifica Papers case. And in that case, the company had obtained lockup agreements or support agreements from about 60% of its shareholders prior to mailing. It was proceeded by way of plan of arrangement, and the court held that the company had breached the CBCA Section 150 by soliciting support in advance of mailing. The lower court held that it still had the discretion to approve the arrangement because it was fair and reasonable. On appeal, it went to the BC Court of Appeal. The BC Court of Appeal upheld the finding that the arrangement was fair and reasonable, but expressed doubt on the lower court finding that the CBC had been breached because proxies or support had been solicited in advance. The court did not express detailed reasons as to why it reached that conclusion, except noting that the CBCA didn't indicate expressly that solicitation could not occur before. So the issue is unresolved, and you will see in Ontario the next time there's a major battle over a plan of arrangement and there are support agreements obtained in advance, someone will take a run at that on the basis that the company has breached the CBCA by soliciting support in advance of mailing a circular. So what are the consequences of those two cases for future litigation? Principal consequences that a corporation has to be extremely careful in obtaining support prior to mailing a circular. It has to be careful and almost perform a cost-benefit analysis that if it obtains support in advance, it may risk having that transaction challenged by a court on the basis that either one, the statute has been breached because it solicited proxies in advance, or two, the shareholder's calculation of majority of minority has not been obtained because the person challenging the transaction will seek to exclude the votes of those whose support has been obtained in advance. So the key thing is when the company's deciding whether to proceed with the transaction, make sure it does the analysis. Is it better off to obtain the support after it mails a circular or before? Thank you.
Thank you very much, Jim. That concludes the presentations. Now, as difficult as it is to keep everybody on schedule, we're really only 5 minutes behind, and you have some of the faculty left. We'd certainly be pleased to take any questions, and because this is being webcast, we got our first question actually over the web. So there's your electronic securities law. So I'm going to address this to the faculty who dealt with continuous disclosure issues. Here's the question. The definition of failure to make timely disclosure in the provisions is conjunctive. The issuer must fail to disclose, 1, in the manner, and 2, at the time required by the Act. This doesn't make sense. It should be a failure to make timely disclosure if either of these take place. Will this be fixed before the legislation comes into force? So I guess my first question is, has anybody ever reflected on the specific language used or seen a circumstance where it's actually been relevant? Anybody want to take a shot at that? I'm getting a lot of shaking heads, so I'm going to guess that the technical issue in terms of the language has not really been a factor, and that in practice, if you blow either element, if you don't generally disclose in the sense that the regulators have through a press release, or you don't disclose in a timely fashion, you're going to breach your obligations. Any other questions before we lose everybody? Well, maybe some of the faculty will hang around for 5 minutes, and I'll buy them a coffee, and you can feel free to ask a question directly. Thank you very much for coming, and please return your evaluation forms. Hopefully you were filling those out, and if the sense is that this was worthwhile to you, we will have the second 6-minute securities lawyer next year. Thank you.